I get asked about arbitration all the time, so let's get into it today. Arbitration is a form of private dispute resolution where the parties agree to resolve their legal issues outside of the traditional court system. Instead of a judge or jury, you get a neutral third party called an arbitrator that reviews the evidence, arguments, and then makes a binding decision. So, why choose arbitration over litigation? Well, here are the main reasons. First, it's typically faster and more cost effective. Court cases can drag out for years and years with very expensive discovery and procedural delays. Arbitration usually follows a pretty streamlined process and leads to a much quicker resolution. Second, arbitration is private. Court records are public, but arbitration proceedings are confidential, and that's ideal for more sensitive business disputes. Third, parties often have more control, so you can select an arbitrator from a specific industry area of expertise or even set certain procedural rules in advance. However, arbitration does have trade-offs. You usually waive your right to an appeal, and if the arbitrator makes a mistake and you get a bad outcome, that can really cost you and you can be stuck with it. Also, costs can rise if you use a panel of multiple arbitrators instead of just one, or if you go through a private arbitration institution. So, when is arbitration the right choice? Well, you typically want to arbitrate when you value privacy, speed, cost control, or want a subject matter expert deciding your case. It's common in commercial contracts, employment agreements, and international disputes. And the bottom line is that arbitration is a powerful tool, but one that needs to be carefully considered when drafting or signing a contract.